Thank you for attending Specialty Docket Expansion and Changes in Misdemeanor Drug Case Processing Across Race and Sex. The Drug Court webinar series is hosted by the Ohio State University Moritz College of Law, Drug Enforcement and Policy Center, and the Ohio State University John Glenn College of Public Affairs, and Cornell University Brooks School of Public Policy Department of Sociology. Before we begin, we have just a few notes we'd like to share with you. First, we want to draw your attention to the Q&A function at the bottom of the Zoom window. The chat is disabled, but you may submit questions at any time. Please note, however, that there is limited time available for Q&A during the webinar. Second, automatic closed captioning has been enabled for this event. To choose how you view the transcription or to hide it, click Show Caption in the menu at the bottom of your Zoom window. Finally, this event is being recorded. The recording will be made available on our YouTube channel as soon as possible following the event. The link will be shared with all registrants via email as soon as it is available. Follow us at OSU Law DEPC to stay up to date on our research, programming, and future events. Thank you again for joining us, and we hope you enjoy the discussion. Judge Thomas.
Hello, and welcome to today's Drug Court webinar. Thank you to everyone for registering for this webinar session. My name is Judge Jody Thomas, and I am a judge at the Franklin County Municipal Court. I am also the presiding judge over two specialized dockets here in Franklin County, the first one being the HEART program, which stands for Helping Achieve Recovery Together, and that is the opiate-specific drug court. And also I preside over Catch Court, stands for Creating Autonomy Through Collaborative Healing, and that is our human trafficking survivor docket. I am pleased to serve as the moderator for the third and final webinar in this June webinar series. This webinar series presents findings from research on drug courts in Ohio, with particular attention to access to drug court programs. This third webinar presents results from analysis of Franklin County sentencing data. We'll begin by presenting these study findings, followed by a question and answer session. The study findings will be presented by Dr. Sade Lindsay. Dr. Lindsay is an assistant professor in the Brooks School of Public Policy and Department of Sociology at Cornell University. Her research examines how criminal justice policy can both alleviate and reproduce social inequalities, with a particular focus on incarceration alternatives for substance use disorders, vocational and educational opportunities in prison, and economic mobility during reentry. We will then be joined in the question and answer, or the Q&A, by Dr. Tasha Purdue and Lydia Applin. Dr. Purdue is an assistant professor at The Ohio State University's John Glenn College of Public Affairs and affiliated faculty in the Drug Enforcement and Policy Center. Her research focuses on substance use, service systems, and policy responses, using mixed methods to inform evidence-based interventions that improve outcomes for individuals, families, and communities. She currently serves as MPI on NIJ-funded research examining overdose response and system-level approaches to supporting families. Lydia is a third-year PhD candidate at the John Glenn College of Public Affairs at The Ohio State University. She's interested in researching criminal justice policy and public services, including policing and juvenile justice. At the conclusion, I will lead with a few questions to start the Q&A, and then we can turn it over to the audience for any other questions. As a reminder, please feel free to submit your questions into the Q&A box throughout the presentation. I'll now turn it over to Dr. Lindsay to introduce the study. Thank you.
Awesome. Thank you very much, Judge Thomas. Let me share the screen. Awesome. So today I'm going to be presenting results from our third and final webinar and phase of this project, titled Specialty Docket Expansion and Changes in Misdemeanor Drug Case Processing. And so thank you all for joining us today. Before I get started, I must say, right, that these findings are supported by funding from the National Institute of Justice, but do not reflect any opinions, conclusions, or recommendations of the Department of Justice itself. I also want to acknowledge our project team. We have 3 principal investigators and a host of research assistants and consultants that helped us on this project with data collection and analyses. And so this would not be possible without this group of us, this team. So the overarching purpose of the study was to examine access to drug treatment court programs, particularly thinking about racial inequality and access to treatment. So the project had 3 phases. Each had its own webinar, so you should check those out if you weren't able to attend. Phase 3 was all qualitative and explored how drug court professionals across Ohio understand and explain differences in access, and also sort of their strategies for addressing them. Phase 2 analyzed racial differences in charging decisions and assessed how those differences ultimately shaped who was eligible for drug court in the first place, using the same Franklin County sentencing data that I will use today for the analyses. And phase 1, which is what I'll talk about more today, examine how introducing the specialty court programs or drug treatment court programs into Franklin County misdemeanor courts, municipal courts, shape sentencing for drug cases over about 2 decades, and whether the overdose crisis itself also shaped how courts approached punishment for substance use related cases. So drug treatment courts emerged out of this therapeutic jurisprudence movement during the war on drugs, actually, but now there are over 3,000 of these specialized courts operating across the US. And so when the programs work, they work really well, right? Participants receive treatment, they get reduced sentences, and research consistently shows that for those who can access them and complete them, right, there are lower recidivism rates and also relapse. However, there are a lot of race and sex inequalities in accessibility. So this is pulled from a study that looked at regional representation by race and sex. And we can see that in the Midwest in particular, which is the red bar, Black defendants are underrepresented in drug courts, and this is compared to other people on probation, so a more comparable group. Male defendants are underrepresented, and white defendants are overrepresented. And the effects are way more pronounced, right, in Midwest compared to all other kind of regions. So one underlying cause that researchers and also many of our phase 3 participants brought up was how drug program eligibility ends up shaping who is getting access and worsening inequalities. So there was a 2021 ACLU report on Ohio drug treatment programs that found of the 73 courts that they were able to survey, 63% had some sort of disqualifying offense for or disqualifying criteria for violent offenses. Past convictions were about 40%, and then about 80% of the courts require some sort of risk assessment. And these are all sort of seemingly race neutral on their face, right, factors, but they interact with the criminal legal system where Black defendants, as we showed in phase 2, are charged and convicted, right, at much higher rates for some of the same underlying criminal behaviors as white defendants. And so we had a participant who kind of who does the intake process, who kind of explained this quite well, right? If the assessment tool asks about prior convictions, and if Black defendants are charged and punished differently in the first place, right, then you're kind of carrying over that inequality into who is eligible and accessible. So phase 2 findings specifically, we showed that Black defendants, all else equal, controlling for a host of factors, that they were convicted of their original charges more likely, more often than white defendants, and they were less likely to receive charge reductions, and white defendants were more likely to have experienced the kind of leniency that Black defendants didn't, and particularly for the charges or the offenses that would make someone ineligible, like violent offenses or weapons charges, drug trafficking, etc. So for phase one, we wanted to think about, okay, just expanding drug treatment courts in a county, what might that do for how judges, prosecutors, et cetera, everyone who has kind of a say in the processing of cases, especially cases with drug charges, right? What happens to those cases over time? And do we see differences before and after these interventions by race and sex? And also, you can't ignore, right, the overdose crisis that was happening alongside the expansion of specialty docket programs, right, and often in response to the overdose crisis. And so we also wanted to see, right, independent of the docket expansion, how the overdose crisis itself shaped sentencing, and how folks were sentenced by race and sex. So again, right, it's important to recognize the overdose crisis alongside this expansion. We can see that drug-induced mortality rates rose nationwide, which is this green line, dotted line here, but the crisis was particularly severe in Ohio and even more pronounced in Franklin County, where we're focused on today, especially after 2017. And the demographics of the overdose crisis also changed over time. White mortality rates were higher earlier on and were catching up actually with Black mortality rates, and then ended up surpassing them. And then Black mortality rates surged in the late 2010s, reaching more than about 80 deaths per 100,000 in Franklin County by the start of the pandemic. And then male mortality rates, right, were always about twice as high as female mortality rates throughout. Right? So this is a crisis increasingly impacting both white and Black populations and predominantly men. So as this crisis sort of progressed, Franklin County had opened up a number of courts and different dockets to address this issue, right? To try to find an alternative that wasn't incarceration for substance use. And each expansion period in 2004, 2009, 2012, and 2014 sort of coincided with the waves of the opioid crisis, right, which was really driving the overdose rates. So we had the prescription opioid crisis to start, then, right, heroin, and then we get into this more dangerous and riskier crisis with synthetic opioids and fentanyl, right, and sort of taking off around 2013, 14-ish. And that's sort of when the standalone opioid court opened around then. And those are the sort of intervention periods that we focus on. Each docket opening, we have a sort of intervention period there. So our data cover over 400,000 misdemeanor cases. We focus on misdemeanor cases for this one, just given that many of the specialty court programs are for misdemeanor cases and not felony cases, though there are some, right, that occur, but we just focus on misdemeanor cases for this phase. And we do so looking back from 2001 to 2019. Each case is classified whether it involved any kind of drug or substance related charge. And then all other cases were sort of the comparison group here. Because we're looking at also race and sex, it's harder to sort of slice and dice the sample into different types of offenses. And so we had to sacrifice some of that nuance and just focus on drug and substance use related charges and not kind of break them out into offense categories for this analysis. The defendant population was about 44% Black, 28% female. Overall, about 38% of cases received a jail sentence. The average was about 19 days. And then about 19% received a probation sentence with an average of about 580 days, just about 1 to 2-ish years. For both of the research questions, we compare sentencing outcomes, right, for cases that have those drug charges compared to cases without those drug charges. And when we look at race and sex, we're comparing, right, within race and within sex in terms of drug charges in those cases. So white women or white people with drug charges compared to white people without drug charges. And then from there, our first question is sort of tracking along the intervention periods, right? So as each court opened, right, what happens to the sentencing trajectories? And then for the second research questions, we look at the county level drug overdose rates. We look at the overall rate, but then also race specific rates as well, and also sex specific. But for this analysis, I will only show the race specific rates. And then we also take into account 2 core outcomes. We're looking at like the chance of punishment, right? So what is your chance of receiving a jail sentence? What's your chance of receiving a probation sentence? When you have a drug charge and when you don't have a drug charge. And then we look at the duration. I'm going to focus more on the chance of punishment just because there's more happening there. Duration, there are some effects, but there's a lot less consistency in terms of the length of a sanction versus whether you're sanctioned at all. And then for all the models that I'll show, we control for age, race, sex, the charge severity. So whether it's M1, M2, 3, etc. The number of charges that a case has, and then also the criminal history of the defendant itself. And so this is saying like all else equal, based on what we have, right? Someone with a drug charge, how are they sentenced compared to someone without a drug charge? And then looking across race and sex. So I'm going to use this general figure to try to get through most of the results. And our first research question, right, is focused on the specialty dockets. So just looking at what happens when you expand those dockets to sentencing for drug charges, and then are there differences by race and sex? All right, so this figure shows the sentencing gap between cases with drug charges and cases without drug charges. The blue bars for jail sentence, or a probability, that difference in probability of receiving a jail sentence. And then the gray bar is that difference in probability of receiving a probation sentence. And so the key takeaway is that drug cases, right, were consistently less likely to receive a jail or probation sentence than comparable non-drug cases. And that difference grew as specialty dockets expanded. So each period we can see, right, those bars go lower and lower, and sort of peaks around a 15 percentage point difference. So someone with a drug charge in 2009 would be 15 percentage point less likely, right, than someone without a drug charge to sort of be sentenced to jail, right? So they were just treated way more leniently than other cases during this period. And then we can start to see it kind of dissipates over time, right? So it doesn't completely go away, which maybe we wouldn't totally expect that, right? But it still is higher than the pre-intervention period when we started, right? Those differences. But it definitely, we start to see this pulling back of that leniency toward really this fentanyl era of the overdose crisis. So when we break this down by race, we still see the same leniency, right? So we still see those bars are going down, right? That means that they're receiving more lenient punishment or less likely to be sentenced to jail or probation. Now the blue bars are Black defendants, the gray bars are white defendants. But for jail, we can see that pre-intervention periods, right, Black defendants with those drug charges essentially had no leniency gap. They were being sentenced just the same as Black defendants without any kind of drug charge. But we do see white defendants in that pre-intervention period having this leniency gap already to start. And that's controlling for all the case level factors and defendant criminal history and such. And then we see that this continues to grow. Black defendants do get that same sort of leniency, but we can still see that gap between Black and white defendants is still visible and present and significant there. So both are experiencing the greater leniency relative to cases without drug charges, but the gap is much like white defendants are receiving a bit more of that leniency. In probation, we see a similar pattern. However, right, there's much more equality essentially here, right? So we see the use of jail there are some racial differences there, but for probation, it's pretty equitable, I would say. And if we look at this by sex, we can see that, again, the blue bars for male defendants, gray bar is for female defendants. That is actually male defendants that are receiving this greater leniency here, where they're much less likely than male counterparts without these drug charges, right, to receive a jail sentence, where women are still receiving that leniency, but it's just not as pronounced. And then for probation, we see a similar trend. Not as pronounced as jail, but still men are receiving a bit more of that leniency relative to men without drug charges. And women aren't having the same level of leniency. So again, I'm gonna kind of go through this a little quicker than I would like, since there are a lot of differences to walk through here. This is the conditional on receiving a jail sentence. How long, right? How much longer or how shorter in this case is the sentence for those with a drug charge? So we can see for overall, across these intervention periods, those who are sentenced are also receiving shorter sentences than those without the drug charges. By race, it's pretty similar. None of these are significant, which is why they're lighter but the patterns are the same across race for the most part. There's some slight differences across periods, but overall, we don't see sentence lengths differing very much. For male and female, we do see, or by sex, we do see some differences emerge. We actually see that the reductions are pretty much concentrated among men, and women are in some eras or some periods having receiving longer sentences than those without drug charges. In some areas are receiving slightly shorter sentences. And so there's much more of a mixed bag. But across the board for men, right, they're receiving shorter sentences and more leniency in terms of a jail sentence altogether. And then for probation days, same sort of setup in terms of conditional on receiving a probation sentence. This one, we don't really see that much difference. Again, we see some shorter periods of probation days overall. By race, they're pretty comparable. By sex, the differences are not nearly as large as they were for jail, but there still are some differences where men are still receiving slightly more shorter sentences for probation compared to men with those without the drug charges. Okay, so again, overall, we're seeing that white defendants and male defendants are receiving this leniency. However, over time, we see that at the beginning, when the interventions first started to proliferate and expand, that's where that leniency was concentrated, and then we see it kind of converge, or this what we call like sort of a slightly punitive reorientation. They're not being treated, they're still being treated more leniently, but not nearly as much as during like the 2009, 2011 era. So I'm gonna kind of quickly go through some of this qualitative findings that kind of set up our second research question and why we think that considering and trying to look at how the opioid epidemic and overdose crisis itself was shaping sentencing decisions is important. And some of that, again, came from the qualitative interviews that we did in phase 3, where we were noticing this sort of moral paradox of being lenient, especially in a time of crisis and what that meant. And so for drug court professionals, right, they were trying to decide often between sanctioning someone or not sanctioning someone, right? You can sanction people for essentially for services and to get them help. But if you kind of overdo it, right, you can risk pushing people away, making it feel coercive. But there were instances, right, where the only option felt like to sanction, right? And so that's kind of what folks are left with. When you don't sanction, right, especially amid a growing drug overdose crisis, that risk becomes, right, leniency sort of is more closely connected to a risk of death. And so our all of this is coming out of like this compassion, this sense of wanting to help and support in the best way, and with the power that, right, drug court professionals have. However, it was sort of this moral paradox that it's a conundrum. Like, what do you do in this situation? This is just one example of this occurring where there was a professional who was talking about how they decided not to sanction earlier on. They were a little more lenient until they started to experience some of the downsides of that leniency. So there was one case where someone clearly was in crisis and needed assistance and help, but to sanction them, to incarcerate them, right, would mean to sort of disrupt all the other things going on in their life as well. And so they said, I'm going to give them another chance, right? And then that person had overdosed shortly after, right? So in that one instance, sort of reoriented how they thought about, how they address someone who's in crisis. And sometimes that meant you have to sanction because that's how you get people some of the assistance and help. On the other hand, there were folks who talked about, right, how some programs, especially among women, where if you were a little too overbearing or trying to sort of micromanage their life, etc., you risk pushing them away anyway, right? And then you don't get them the sort of help and services that they need. And so this pointed us toward our second research question, where we wanted to know, right, how the crisis itself was shaping, right, how sentencing was happening and whose crisis essentially was driving sentencing outcomes for people with drug cases and drug charges. So this is just, I want to go through this quickly, but this is a figure that plots the predicted sentencing rates for jail and probation. And the gray bars are cases without drug charges, the red bar cases with drug charges, and the bottom line, the x-axis is overdose rate. And so we can see that the red bar here for jail sentencing, it's moving a little bit, but it's not moving quite as fast as and rising quite as fast as cases without the drug charge, right? And so there's still that leniency, even as overdose rates are rising, right? We're getting to 40. We're not seeing that same kind of punitive trajectory as other cases in the county. And for probation, we can kind of see that what might be happening is, like, we're starting to place people in probation, right? We can kind of see those lines are more parallel, still a gap, but the growth for probation is a bit more pronounced than for jail and sentencing. And so that's capturing, right, some of that, the leniency that's occurring, even as this epidemic is taking off. And then this one just shows, if we look at white overdose deaths on the left-hand side, now we're not looking at overall overdose deaths. We're just looking at white overdose deaths. And then we are looking at white and Black defendants on the left side. We can see that same kind of pattern. It's right, the same kind of pattern that we saw in the last figure for jail sentence is occurring across defendants' racial groups, right? So the white overdose rate isn't just, helping or leading to different sentencing for white defendants. It's also happening for Black defendants. But when we look at the Black overdose death rate, which doesn't go nearly as high, however, it's pretty flat, right? There's not really any difference. And so the response is happening, right? This leniency is still being tied to rising white overdose rates and not necessarily pretty much no response to Black overdose death rates across defendants. So to kind of bring most of this together, again, we're trying to grapple with a lot. This is a sensitive topic to talk through and to have a really nuanced discussion about, right? Because specialty courts aren't operating in vacuum, right? They're responding also to what's happening in the county overall. And so what we found essentially is that there was this growing leniency, and then there was this adjustment that happened toward latter periods, and some of that, right, might be tied to this moral paradox, right, where people start off, trying to be understanding and supportive and being more lenient, but then there's this adjustment as you learn, and you learn clients, you learn the defendants in front of you, et cetera, where there's this sort of reorientation that happened. And there was still a racial gap, right, to even start, where Black defendants weren't receiving leniency until we started opening up the dockets. So they benefited from that leniency, just not nearly as much as white defendants did. And then male defendants in particular also benefited from that leniency. And then for the second question, the crisis really widened the gap in who got sentenced, but it compressed this gap in like how long. I didn't get to walk through all of the findings here, but across all of it, right, it's the leniency was really tracking this white overdose rates, overall overdose rates, but really driven by, right, white overdose rates. And it sort of tracked for both Black and white defendants. And so, but there wasn't the same difference in how sentencing was happening for Black overdose rates. So to just sort of bring it back out, because I know I'm a little over on time here, I do want to kind of make sense of this just a little bit, and we'll get into this in the Q&A some more as well, that our findings are kind of pointing toward these 4 recommendations that a lot of the phase 3 stakeholders brought up, which first is that courts could have their own, I would say, little statistical units, or you can call it research units, to monitor, right, sentencing patterns. We have all of this data. We have the means in terms of we're measuring it, but thinking about how we can track who's participating, but also just general sentencing, what that is, what's happening as we're diverting more and more people, what's happening to sentencing overall in the county. Secondly, we can sort of broaden eligibility criteria a little bit. We talked about this in our previous webinars as one way to kind of capture some of the inequities that might be impacting our estimates here, right? We don't know who is actually going into the program. We're just kind of looking at the aggregate effects overall in this analysis of opening a docket. And then third, we think that courts should assess whether the crisis-driven response are sort of reaching all populations, right, that we're in tune with overdose rates and other sorts of crises that are occurring in other populations, right? We were responsive, especially during the earlier years of the opioid crisis, and shifting gears and trying to adapt. But we don't really see much movement when we looked at Black overdose rates. And then fourth, this idea of this moral paradox of like, how do you deal with and make decisions in this context of where the risk is rising in terms of being lenient isn't just being compassionate sometimes, right? Trying to get people the services that they need by sanctioning them is also going to be sort of like perceived as a compassionate response in order to help someone. And how do you balance that with, it's just like a conundrum that we think that organizations, Ohio Supreme Court, other sort of professional organizations could come up with resources, right, to help drug court professionals grapple with, the signs of someone in crisis, especially folks who are just joining drug courts. We had some newer participants in our study who were like probation officers, et cetera, who are just coming into this environment. And so having some guidance and identifying the signs and those sorts of things might be helpful in dealing with that, the morality issue of punishing or not punishing someone. There are obviously some limitations. So we are only looking at Franklin County here. This is the county that we have data for. We were able to get data for. This may look different in other counties. As I show, Franklin County is clearly a county that is dealing with the overdose crisis in a way that other counties in Ohio aren't, and even nationally, right, aren't having to deal with the same kinds of crises. And so it's an interesting case in that, but it's just a case, right? Also, we have, there are like a lot of issues in terms of we can't identify who is actually diverted into drug courts. So we just can't make a causal claim in terms of drug court itself is shifting these things. But we can say, right, that on the aggregate, this is what's happening when you're introducing drug courts into a county. This is what's happening to sentencing for people with those drug charges. Other things that we want to do, we have data post 2019. We want to think about, right, COVID and what that did to this environment and inequalities. There were also some other courts that were dockets that were opened. And then other factors, right, like suicide rates may also be something that we can look into given the co-occurrence, right, between substance use disorders and mental health disorders and so on and so forth. And then exploring this moral paradox of leniency idea more in our phase 3 qualitative data is also something we'd like to do to see if this is really a broader phenomenon occurring. But yeah, thank you very much. And I'm looking forward to having greater discussion and answering some questions that you all have.
Thank you so much, Dr. Lindsay, for that insightful presentation. Overall, this study highlights that as Franklin County expanded specialty court programs, drug cases initially received more leniency, but the court pulled back over time, and that shift played out differently by race and sex. The findings also show that the court's leniency response tracked white overdose trends, regardless of the defendant's own race. Now, there's a lot to unpack here, and I'd like to start us off with a few questions. I think we've got all of our other presenters here. The first question is, you all showed that the court's leniency responses tracked white overdose rates, even for Black defendants, and that outcomes shifted differently across intervention periods, despite the programs pursuing similar goals. Can you talk about what may have driven that variation and how those factors worked alongside the specialty docket expansions?
Sorry, I didn't realize I was not muted. Yeah, so this is something interesting because we're right. We're looking over time, and in thinking through both the quantitative data and the qualitative data that we have, we could see that, right, people are learning as they go, right? Once the overdose crisis began in the early 2000s, right, you have to set up this infrastructure and you kind of learn over time, like what works, what doesn't work, you adjust. And we saw that, right? Like this idea of being lenient at first, right? Because you want to give people a chance, you want to help folks, but sometimes you do have to sanction, you do have to let people rise to the sort of standards that are set, because a lot of people they kind of need that support. And so I think some of those shifts and changes over time just come from the fact that, court professionals themselves are learning more and encountering more cases and learning the signs, and able to act on that in ways that are fair, but still can help support someone long term and in the end. And sometimes that meant, right, if you were in a program and we've given you a chance and another chance, right, that meant that you do have to sanction and to avoid some of the risk that I talked about from the participants. And so I think that a lot of that is driving just the learning over time, and then also adjusting as the crisis is developing, and you're learning your program and developing it more. I don't know if Lydia or Tasha want to chime in.
No.
Yeah. So I think thanks, Shade. I think that's a great question. It aligns closely with what we've heard from stakeholders in phase 3. So the findings suggest that changes in how substance use is viewed, shifts in policing, enforcement patterns, and variations in decision making are all important, but and in shaping that early stages of the access pathway. So stakeholders frequently pointing to shifting views on substance use from a more punitive model to a more treatment-oriented approach as influencing who is seen as appropriate for treatment courts, which in turn affects how individuals are identified, whether they're perceived as viable candidates for treatment, and this can how strongly different actors support referral. So these changes in enforcement practices and policing strategies shape who enters the system in the first place, and the decisions around how cases are charged or resolved through the plea agreements play a role in determining the eligibility, whether individuals are considered for the program. So the phase 3 findings really add that these broader shifts don't operate in isolation, and they're instead interacting with also what happens downstream within courts, teams, and programs themselves. So they also, stakeholders identified how access unfolds across multiple stages. So that's the identification, referral, admission, participation. And at each of these stages, we have different factors coming into play. So we have the sort of organizational factors within the team, the individual level factors, that awareness, the trust of belief in treatment itself, and then the process factors. So the referral pathways that may exist, that just the discretionary decision making as well. So rather than being driven by one single factor, this access is really this interaction of these elements across these stages. And really these small differences at each step do accumulate over time. And that's why we really conceptualize access as this sort of cumulative process rather than something determined at that single decision point.
Thank you, Dr. Perdue and Dr. Lindsay. All right, my next question is, the qualitative data introduced this idea of a moral paradox of leniency. What do these findings suggest about the relationship between treatment-oriented interventions and punishment? Are there ways that treatment programs may inadvertently contribute to more punitive outcomes for certain groups?
Yeah, so I think that this is something that we're still kind of working through, and to try to understand what's going on and might be driving some of these patterns. And so this idea of a moral paradox of leniency is just that, right, that you can do things that may make a program more conducive to certain groups and more helpful. You can be a little bit, like, you can design a program that maybe is a little too, some of the participants say, like, paternalistic in a way, right? And it kind of defeats the purpose of having the program in the first place if participants feel like, right, it's a little overbearing, or it's, right, we're dealing with folks who have a lot of trauma, right? And if it reminds them of abusive relationships or controlling relationships, that sort of tension there, right? You might drive the population that you'd like to support, and you have good intentions of supporting away. On the other hand, right, there's being too lenient or too not having enough structure, right? The programs are there designed in a way to add that structure, the accountability, the support groups, the resources, right? I see the court programs really as like these institutional brokers in a way, and helping people get access to services and how they've evolved over time, right? But if you're sort of a little too lenient, if right, you develop these great relationships, but if right, as you develop them and you're kind of making exceptions here, I'm not saying this is always what's happening, but this is kind of what we were picking up in some of the interviews where people were trying to give second chances here and there, or encountering situations where they were unsure if they should be sanctioning them in a way where it could mean that your probation is revoked, or it could mean that right, there are consequences to the sanction itself. But if you don't, when someone is in crisis, or we're in this period where, even if someone is doing fairly well, but we have right fentanyl and these other sort of these high risk and deadlier consequences to the leniency, or just sort of giving people the benefit of the doubt and helping people, essentially, is how I think of the leniency. Not going strictly by the book in the same way, using your discretion to kind of make those decisions. They can have those consequences that like someone may pass away, or have there's right, and that's a lot to have to carry on yourself. If you thought, if I just stuck by the book, this person maybe would not have, passed away, etc. And so I think it's something that it came up a decent amount, and something that I think there are organizations or the Ohio Supreme Court, someone above can kind of set some sort of guidance or guidelines and standards to help navigate some of those conundrums that come up. I don't know if Tasha or Lydia want to add
to that question?
anything.
Okay. All right.
Oh.
Last question, then. Oh, go ahead.
Sorry, I just had one thought on that. There are some courts that we observe that do have some sort of structure that allows for discretion, like different like matrices or like other systems that allow for, if someone's in this phase and this circumstance comes up, like what are sort of our sanction options, or like what are the ways we typically respond. But they still talked about it is really tricky, and you have to sort of consider things on a case by case basis. And yeah, I echo what Dr. Lindsay shared about there are, a number of people working in this space who are legitimately really worried about, if I don't sanction someone or don't sort of enforce something, how could that really impact their livelihood? So yeah, I think that it's just really, really complex and really difficult for people to try to navigate.
Thank you. All right, my last question, and then I see that we have some audience questions. Given that sentencing outcomes shifted differently across demographic groups, what concrete steps can drug courts take to ensure that the benefits of specialty docket programs reach all the populations they serve?
Yeah, so I think that there were a couple of things that really came up in our phase 3 portion, the qualitative interviews. One was having more outreach, but like strategic outreach. So, especially for like trying to get more Black defendants into the programs, where there could be a bit more strategy. I think there were some folks who were going into the communities, going and trying to connect with like local churches, and like just being way more strategic in trying to build that trust, especially given that there's going to be some like deep distrust in wanting to be connected to a program for an extended period of time, to show up way more than you might have to, right, for a typical probation sentence, if that's your alternative. And so those are the kind of ways that I think the outreach, the education around different like Narcan and breaking down some of that stigma that can be in communities of color. And then also some interesting things that I heard from some of the interviews around like getting grants and how they sort of strategically use grants from other, like there are a lot of opioid related grants that folks can receive, but opening that up to not just, you know, the opioid docket, but everyone being able to kind of partake in some of the programming in a way. So you're spreading the resources in a way that, you know, allows other programs that maybe aren't funded as well, or you can't kind of get the same kind of resources. You're still supporting a wider community. I don't know if Lydia or Tasha want to add on.
Yeah, I would say in addition to expanding eligibility outreach and the culturally responsive services, the phase 3 findings suggest that ensuring equitable distribution of the benefits requires attention to how the system operates across each stage of access. So stakeholders emphasize the need to standardize and clearly communicate eligibility and referral criteria, and to help reduce the variation driven by more informal or subjective decision-making by those referral stakeholders. And then also strengthening and broadening referral pathways so that this identification does not depend on a single actor or point in the process. And then equally important in improving coordination across system actors, so judges, prosecutors, defense attorneys, treatment providers, to ensure that shared understanding of the goals and consistent application of the criteria. So stakeholders emphasize the importance of directly addressing barriers to participation as well, such as transportation, childcare, housing, and employment demands, which can disproportionately affect certain groups and limit engagement. So even after admission, there are still barriers that can be operating. And then a key takeaway is the need to track access across each stage. So identification, referral, admission, participation, and use that data then to identify gaps and make ongoing adjustments rather than focusing only on the outcome. So kind of seeing at each stage of the process how things are looking. And really these points reinforce that this access depends on not just who is eligible, but how consistently these processes are implemented across the full pathway into and throughout the program.
All right. Thank you, Dr. Perdue. I think we have just a few minutes for some questions, and I do see some. Dr. Lindsay, do you want to?
Yeah, I can read them. I feel like I might have hit on a couple. I tried to with the leniency one. Yeah, for leniency, I'm thinking of this as the question is, could you define what you mean by leniency? Are we talking about sentencing prior to specialty docket entry or leniency once the participant's in the docket? So for the analysis, we don't know who is in what docket, unfortunately. So we're kind of thinking about this as the aggregate. So this is the final sentence. So, right, if let's say you drop out of the program, let's say you were technically in the program and you dropped out, or you got your probation revoked and you were sent to jail, then I'm looking at the jail sentence there that is resulting. So we're kind of capturing some of that, but we would be missing that process that would have occurred, that you entered the program and then you dropped out, or et cetera. We just don't have that kind of finite and nuanced data there. But in terms of, leniency, it's that end stage of like, what was the final result of the case? So we don't capture, maybe they were given 2 or 3 chances, or, right, we just don't know that kind of level of nuance there in terms of leniency. And then the other one is there any insight on the use of the term leniency over appropriate therapeutic adjustments? I like that question. And I think I chose leniency again because, or we're thinking of leniency even in phase 2, in this phase, because we're talking about the actual sentencing outcome. So we are talking about the punishment itself. We don't know, like maybe they were sentenced to jail and then they continued treatment in the facility. Like we don't have like the kind of the nuance in that way to be able to disentangle. Maybe they still were able to get the therapeutic help, but in terms of the punishment, we are measuring that as a bit more lenient. I don't know if Tasha or Lydia have anything to add in terms of leniency there, but it's just those are good questions. We just don't have that kind of data to tease them out. Maybe in the qualitative we could.
Absolutely. Oh, thank you. Well, I think we are about at our time. So I want to thank you to our presenters for sharing their work and their insights. And thank you all for joining us today on this final webinar series. Thank you.